Welcome to Oil and Gas with Energy Law Prof. Today we're going to talk about what happens when your tract isn't big enough for its own well. We'll talk about different solutions that you can have in that circumstance. We've already talked about what happens when you have a tract of land, it's big enough for a drilling unit, you get your single well, and there's a legal location. But what happens when you have a smaller tract of land, and so normally you would not be allowed to have your own well? We'll talk about the approach in most states, which is pooling, and we'll talk about the Texas approach, which Texas didn't take that approach of pooling for many years and now does, but it was a long journey to reach that point. It sort of maybe reminds you of a supposed Winston Churchill quote. Wasn't actually him, but supposedly he said that Americans can always be trusted to do the right thing after they've tried all the other alternatives. And that's a little bit of what Texas did in terms of charting its own course towards eventually getting to pooling. But remember what we talked about in previous classes. Generally, if you have enough land for a drilling unit, here, imagine that black acre and white acre are both 20 acres, and so they both get one well. Black acre can drill its own well. White acre, if it had to drill in the legal location, say that was right at the center of the tract, it wouldn't get to produce oil and gas. So it needs to ask for an exception to drill in an alternative location. But what happens if one of the parties doesn't even have enough land to drill in any location? So imagine that you need 40 acres to drill, and white acre, in this example, doesn't have 40 acres. So what could white acre do in this circumstance? Well, one choice, and the choice that most states would make, is that they would pool this land together. And they would say, okay, black acre and white acre, why don't you both share all the oil from this single well? On the other hand, we'll see that Texas took a different approach, which said, basically, white acre, why don't you drill your own well? So maybe normally you need 40 acres, but if you only have 20 acres, you can go ahead and drill your own well. And we'll see some of the challenges that created. Now, first, I just want to go over a little bit of terminology that we're going to use a lot in the upcoming two videos. So pooling versus unitization. These are different concepts, and it's important that you keep them separate in your head. So pooling, which we'll be talking about today, is when you bring together a couple pieces of land to produce oil and gas from a single well. So that's basically bringing enough land together to drill a single well. By contrast, unitization is when you bring together all the land on a given oil and gas reservoir or field, and you operate it all together in the most efficient ways. Maybe some of those wells you have to shoot water or gas down to force oil and gas out of other wells. It can be very complex, but typically it's bringing together lots of different wells to operate the whole field together. Unitization is much rarer under American law because you can imagine it's hard to get all those different landowners to cooperate. Sometimes you can force them to work together, but we'll see that's quite complicated. Pooling, by contrast, more common, and that's just when a couple landowners come together to drill a single well. So let's think about that problem again, where neither landowner, black acre nor white acre, has enough land to drill its own well. How do we handle that situation? Well, let's talk about how Texas handles that situation, which is by exception locations. They basically say, if you don't have enough land for a well, that's all right, we'll make an exception for you, and each landowner can have his or her own well. So generally, exceptions are available when applying the spacing and density rules would mean that you have waste or failure to protect correlative rights. We've talked about what that means. Waste means oil and gas left in the ground. You wouldn't produce all the oil and gas because nobody would have the right to drill. And failure to protect correlative rights means somebody else is going to take your oil and gas from your land. And so you generally are going to be able to get an exception location. So that's how Texas has dealt with this small tract problem. You don't have 40 acres? No problem. Even with 20 acres, we'll let you drill an oil well. So the general rule in Texas that this is an exception from is Rule 37. So Rule 37 has spacing requirements. It says that your well normally has to be 467 feet from a property line and 1,200 feet from another well. There's also density rules. So as an example, those are under Rule 38. And as an example, you could say you need 40 acres to drill an oil well or 160 acres to drill a gas well. Texas generally will give you an exception to prevent confiscation. So if your property isn't big enough to meet that Rule 38 density requirement or to have the right spacing under Rule 37, no problem, we're going to give you an exception to allow a well on your property. Now that's an exception to prevent confiscation, and it's typically granted as a matter of right. It's your right as a landowner to drill for oil on your property, even if it's smaller. Now that right is limited by the voluntary subdivision rule. We'll talk about what that means, but basically the idea is if you try to subdivide your property and sell it off to lots of different parties so each of them can get a well, typically they're not all going to be allowed to have a well. If you would originally have been able to have only one well before your property is divided, only one of those landowners is going to get a well. Now that voluntary subdivision rule is limited because it says, still one person gets the well. So it's not like we prevent all those smaller landowners from having a well. One person will get it. And as it turns out from this Ryan versus Pickens case, we'll see only the first one to have authorization to drill is going to get that oil and gas. Texas also had a very bizarre rule for a while, and it still applies in some circumstances, that said, if you have a smaller property with a well, remember that allowables have typically been determined by how much acreage you have attached to a well. So generally, that smaller piece of land with a well will be able to produce less oil. You can imagine that that might mean it's not even worth it to build a well on a very small property. Now, you might think, well, that makes sense. We don't want wells everywhere. Well, Texas didn't quite think that made sense. In fact, Texas, for a while, gave what are called living allowables, which is sort of a bonus for those smaller wells so that they don't get just their acreage share. They're able to produce a little bit more so that they could justify the cost of a well. And so, those are called living allowables because they make that well viable. I guess the idea under Texas law is, hey, if you're a property owner in Texas and you don't have your own oil and gas well, are you really living? So, living allowables. They are established in this case, 1946, Railroad Commission versus Humble. It's the Hawkins Field case, sometimes it's known as. That says a small tract gets a living allowable that provides an opportunity to recover those drilling and operating costs plus a reasonable profit. Very common way to distribute allowables is instead of using the normal rule that says, hey, you get however many acres you have, that's the proportion of oil you have. Instead, it basically says, look, if you have a well, that means you get a certain percentage of production from the field. So half of your allowables are determined in that way, and the other half of allowables for the field are determined on an acreage basis. And that functionally gives a bonus to those smaller wells over and above what they would get just on the basis of their acreage. Now, that created some very bizarre circumstances where you had a lot of wells with really disproportionate production close together when a property had been subdivided a number of times. And so you had lots of wells, each on a 1 acre lot, kind of absurd results in some cases. So only 16 years later, the Texas Supreme Court in the Hal Booty case, also known as the Poured Acres case, says, you know what? Sorry, never mind. Those living allowables were a very bad idea. Let's go back to that fair share rule. The idea that everybody basically gets an opportunity to produce the fair share under their property, which usually means we determine those allowables on the basis of acreage. Now you might say, well, this was only a 16-year period. Why is this still relevant? Well, the reason is the Poured Acres case only applies prospectively to new fields. So for fields that were discovered before 1962, And remember, there had already been 60 years of intense oil production in Texas, and some of those wells are still producing today. They still get governed by those old rules, which said you get living allowables on those small tracts. So it was the case that you had these extra kind of bonus applied to these small wells that allow them to continue to operate, and some of those still might be in service today. Okay, clearly, this bizarre Texas rule that says you get an exception to drill no matter how small your property is could create some bad incentives. So, imagine that you have two properties that are next to each other. And imagine they're both 40 acres. It takes 40 acres to drill for oil. Now, imagine that the second property owner says, I've got an idea. I'm going to divide my property in 4. And so the property owner on the left only gets 1 well, but I'm going to get 4 wells for each of these landowners. And so my property in aggregate will now be worth more. By the way, that means when I sell it, I can sell it for more than if I sold it as a single tract, especially because of those living allowables, that those 4 tracts could be worth a lot more in aggregate than that single tract. So the Texas had a rule to limit that very quickly, the voluntary subdivision rule. And I'll read it quickly. A subdivision creating a tract of such size and shape that it's necessary to obtain an exception to the spacing rule before a well can be drilled is a voluntary subdivision, and therefore it's not entitled to a permit to prevent confiscation of property. If it was segregated from the larger tract in contemplation of oil or gas or geothermal resource development, or it was segregated by fee title conveyance from the larger tract after the spacing rule became effective and the voluntary subdivision rule attached. So what does this mean? Basically, it means if you're trying to get an exception to produce oil from a reservoir that was discovered before your land was subdivided, you're not going to get that normal exception as of right. Okay, there's some limits to this. Let's talk about them briefly. So, first, the rule actually applies pretty broadly. So the date from which the voluntary subdivision rule is going to apply is going to be the first date of oil and gas discovery in that reservoir, in that field. So even if it wasn't known that the field extended as far as your property when your property was subdivided, the voluntary subdivision rule will still apply. Same thing is true if multiple reservoirs are discovered vertically. The date the subdivision rule operates from is the first date that any reservoir was discovered in this area. And also, if you have fields that were thought to be separate and are later determined to be the same field, again, the subdivision rule applies from the first date that the oil is found on both of those wells. So they're treated as one field now. Now, there is an equitable escape hatch that basically says if for some reason it would be particularly unfair to apply the voluntary subdivision rule, it won't necessarily apply. Okay, so now think about what happens with the voluntary subdivision rule. So again, think about those two neighboring property owners, each with 40 acres. And imagine that the right property has been divided into 4 sections. Now, if the voluntary subdivision rule applies, does that mean none of these property owners can have a well? Well, no. Effectively, the Century doctrine from the later Century case says that one of those property owners get a well. So if the whole 40 acres before it was subdivided gets 1 well, then one of those 4 property owners gets a well. Let me read this for you. Where independently of the voluntary segregation, the larger tract, including the segregated tract, is entitled to an additional well to protect the vested rights of the owners of such larger tract to recover their fair share, the permit to drill on the segregated tract will be upheld, even though the application be made to drill only upon the voluntarily segregated tract and only by the owners of that tract, and be contested by the owners of the remaining portion of the larger tract. So the answer is no. You still get 1 well, even if your property was subdivided in contemplation of oil and gas development, which basically means after oil and gas was found. Now, this is a case you only have in the notes, but it's on page 737 from Texas in 1955, and it answers a question that maybe has already occurred to you, which is, okay, so Pickens and Ryan, they both own part of a tract that was subdivided after oil discovery. So that means, without an exception, nobody gets a permit. Now, the Century Doctrine says that one party is going to get a permit, but which of those parties gets the permit? Well, the Railroad Commission gives Pickens a permit to drill where it's best to develop the whole tract, but Pickens doesn't want to share with Ryan, the other owner. And so Ryan sues, saying, look, you are confiscating my oil because I'm not allowed a well because the Century Doctrine only allows one well, so you should have to share with me. Now, the court actually upholds the Railroad Commission and says, nope, Pickens gets all the oil. This property has not yet been pooled. We'll see later Texas adopts pooling, so this result wouldn't necessarily hold, at least it wouldn't be so harsh going forward. But the court says, no, Pickens gets all the oil because Pickens was the first to drill. Okay, so you might wonder, is there then a race for the Railroad Commission? Which of us can be the first to drill? Only one of us is going to be allowed to drill. And the short answer is, well, kind of, in the sense that if you sleep on your rights, maybe you're not going to, your other neighboring property owners are going to get the right to drill, and you're not. But in fact, really there's an incentive to pool, and this is for a couple reasons. Okay, so first, if all of you apply at the same time, you're not sure who's going to be given that right to produce. And so you may just want to agree with your neighboring landowners, hey, let's share in this. The other thing to keep in mind is allowables. Remember, unless you have living allowables, allowables are typically calculated based on how much acreage is allocated to that well. So if you pool and all 40 acres, all 4 landowners come together, that's going to give you a larger allowable share from the oil. So you're going to have more oil that you're able to produce each day. So there's a potential benefit for all of you. And then, as we'll see, Texas eventually comes around to allowing pooling. So nowadays, if you were on a newer field and forced pooling was allowed in Texas, if you left out that landowner, they would be able to go to the Railroad Commission and demand a share of the oil being produced because, after all, some of it is likely coming from under their land. So, just to give you a brief history of Texas conservation law, and remember, some of this is still important because those old wells that are governed by these old rules are often still in operation today. So, generally, of course, you have the rule of capture, which means the background rule is the first person to produce the oil gets to keep it, even if it came from under the neighbor's land. Now, there are rules that limit how close wells can be to each other or to the property lines, how many acres you need to have to drill, but Texas has been very aggressive in granting exceptions for smaller tracts, and so you still get that exception as a matter of right if your tract is too small for drilling. Now, that was actually further incentivized by living allowables, which gave a bonus to having wells on a bunch of small properties versus to just coming together to pool to share a well between property owners. Now, the Port Acres case after 1962 cuts off living allowables for fields discovered after that date, and the voluntary subdivision rule says if you divided your property after oil and gas was discovered, then you're not going to get that exception as of right. But remember that under the Century Doctrine, if the larger tract would have gotten a well, then at least one of those landowners gets the well. And under Ryan, it's the first landowner to drill that ends up with that one exception well that's allowed by the Century Doctrine.